Today I want to do something that's a little bit different for you. I want to talk to you about long-term trusts, beneficiary-controlled trusts, and dynasty trusts where the client's goal is to preserve or perpetuate or protect wealth for typically more than one generation. But I also want to talk to you about our experience in finding out who does these and why, and how you might be able to use that in your own practices and in your own marketing, because we've been pretty meticulous about studying exactly who does these, why they do it, why they tell us they come in, and what they tell us was useful and good and beneficial to them when they leave. And I have 9,000 clients, so we have a pretty good experience over about 29 years. Somebody was making fun of me because it says in the bio, I guess, more than 29 years. I'd like to keep a little mystery. And so we have a lot of data over a large number of people. And I'm fortunate to live in an area like you do where there's a fairly significant amount of concentrated wealth, but it's a very diverse area. So I could talk to you a little bit about who's making these decisions for a lot of different reasons. I want to give you the information that you need to know to be able to assist your clients no matter what area you're working in. And I will tell you this, if you're not the lawyer and you're giving them some of the information that I'm going to give you today and some of the ways of thinking about these things, you're going to get more credit than the lawyers do anyway. So all I've really wanted to do so far is kind of describe beneficiary-controlled trust, which is more typically where the parent is putting money in trust for a child predominantly for the purposes of creditor protection for that child. If they give that child a general power of appointment so the child could say wherever it goes, then that's going to be includable and taxable in that child's estate. If we want to make sure that it's going down to the grandchildren, then we won't give them a general testamentary power of appointment. We'll just give them a limited power of appointment or no power of appointment at all, and we'll say where it goes when they die. Even if they have a general power of appointment, I'm assuming you could do this in Nevada, and I think in California too, you could disclaim the general testamentary power of appointment. I think so. We can. So even if you give them the power to, if the parents die and the money goes into trust, as long as it's done within the 9 months, they could say, I don't want that power. And then it's going to go, if it's a well-drafted document, down to their kids. And they can achieve a kind of a dynasty trust. They can make it last longer. So beneficiary-controlled trust, maybe it will last multiple generations, but it's at least designed to last for at least one generation and then to give typically that child the ability to decide where it's going to go. The difference between that and the dynasty trust is the dynasty trust is going to fully allocate the generation skipping transfer tax exemption to the trust. That means if we have a husband and wife, we can move almost $11 million of net worth, if we're not using any leveraging, into a trust, which could be in trust for however many kids we have. They could use it, get the benefit of it during their lifetime, and then when they die, or at some point, it's going to go down to the next generation. It is worth talking to clients about that. Should spouses ever be allowed to get it? Should we give a limited power of appointment where a kid, one of your kids, could let their spouse get the income and then have it go to the children at death? There are all those things that I've alluded to that are typically not discussed very thoroughly with clients. They just end up with these trusts that have sort of taken a position on that, and I encourage you to talk to them about it because it makes them much more comfortable with this. So those are the two types of trusts. Mm-hmm.
Even if they don't have upwards of $11 million, do you still recommend, let's say they're worth $3 million, is that still a recommendation to protect, from liability and divorce?
Yeah, you're going right to where I'm going, which is who does these and why do they pick between one or the other? So this is a great question. Would somebody with a $3 million net worth ever do one of these things? I find, again, in my own practice that tends to sort of fall along the lines of how many kids they have in relationship to the amount of wealth. So typically, if somebody has $1 million of non-IRA assets, because Brenda's going to talk about this all hangs together. She was a genius in how she put this together, because we're talking about how do you protect your stuff during your lifetime? How do you protect stuff for the next generation or possibly longer? And then how do you do it with respect to IRAs? Because that's a little bit of a different beast. But if we take the IRAs out of the equation for just a second and we pretend that the bulk of the assets are just non-tax deferred assets, if I've got somebody that's got $1 or $2 or $3 million and one child, these are absolutely planning techniques that make sense for them. Spending the extra money is often something they're perfectly happy to do. But if I've got somebody that's got 3 or 4 kids and $1 or $2 million, it doesn't make sense. I mean, people still sometimes do it, but you're not going to get the real benefits of the kind of flexibility that you would have in these trusts. Generally speaking, and I'd be curious on your view, my view, having seen these sort of pan out and advising the trustees from time to time or acting as a trustee occasionally, my view is that if it's not $1 million or more, I'm not saying don't do it. I'm just saying a lot of times they end up wrapping these up. It's like family charitable foundations. In my experience, people set them up for $500,000 or $700,000 or $1 million or $2 million. And statistics nationwide bear this out. That isn't even going to last a generation. Somebody's going to get sick and tired of the paperwork pretty soon, and they're going to merge it with a community foundation or something like that. In fact, while I was chairman of our community foundation, we had 4 or 5, $1 million to $2 million family foundations that just, created basically donor-advised funds and wrapped them up. It's the same with these trusts. If you set them up, the expenses of the trust and the logistics of the trust are the same, whether you have $500,000 in there or $5 million. So that I'm sort of saying $1 million on up, they almost always seem to work. $1 million on down, they almost always seem to get terminated at some point. Is that? You feel free to disagree.
I would tend to agree. I haven't seen a lot of them in administration.
He's saying he's much younger than me. He's trying to say I'm not old.
But yeah, I mean, it makes sense because you've got the income tax return to do and all that.
Yeah, and you've got to keep the trust records a little bit more, carefully than you would keep your own.